Everything I share today is for educational purposes only. This is not legal advice, and I am not your attorney. If you believe you were entrapped by law enforcement, contact a licensed criminal defense attorney in your state immediately. An undercover officer spent 6 months becoming your closest friend. He introduced himself through mutual contacts. He came to your home, met your family, built your trust completely. Then one day he asked you to help him with something illegal. You said no 3 times. He kept pushing. He said he desperately needed your help, that his life depended on it. You finally agreed. The moment you did, 15 officers appeared from nowhere. You were arrested, charged, and the man you thought was your friend testified against you in court. Was that legal? Did the government just manufacture a crime that would never have happened without them? That is entrapment. And the law around it is far more complicated than most people realize. The issue. Law enforcement in America uses undercover operations constantly. Officers pose as drug buyers, weapons dealers, terrorists, and criminals of every kind to catch people breaking the law. These operations are legal, they are necessary, and they produce real convictions of genuinely dangerous people every year. But there is a line, a constitutional and legal line that separates legitimate undercover police work from government-manufactured crime. When officers cross that line, when they do not simply provide an opportunity for crime but actually create the criminal where none existed, that is entrapment. And entrapment is a complete legal defense that can result in full acquittal. The legal question is exactly where that line sits, and why it is so difficult to prove even when it seems obvious. The law entrapment as a legal defense has its roots in the 1932 Supreme Court case Sorrells versus United States, a Prohibition-era case where a federal agent posed as a friend, repeatedly begged a defendant for illegal liquor, and used their shared World War I veteran status to emotionally manipulate the request. The Supreme Court ruled for the first time that government-induced crime could be a valid defense. The modern entrapment standard was refined in Sherman versus United States in 1958. The court established the 2-part test that most federal courts and the majority of states use today. Part 1. Government inducement. Did law enforcement induce or persuade the defendant to commit the crime? Simply providing an opportunity to commit a crime is not inducement. If an undercover officer offers to buy drugs from someone who immediately agrees, that is an opportunity, not inducement. Inducement requires something more. Repeated requests, emotional pressure, exploitation of friendship or sympathy, threats, financial desperation manufactured by the officer. Part 2. Predisposition. Was the defendant predisposed to commit this type of crime before the government contacted them? If the answer is yes, if the defendant was already willing and ready to commit this crime, then entrapment fails as a defense even if significant government pressure was applied. A career drug dealer who sells to an undercover officer after minimal contact was predisposed. The government simply provided the opportunity. The critical problem with the entrapment defense is this: predisposition is judged at the time the government first made contact, and prosecutors use prior criminal history, prior statements, prior associations, and any evidence of willingness to commit the crime to establish predisposition. Defendants with prior records face an almost impossible burden proving they were not predisposed. Some states use a different standard called the objective test. Under this test, the question is not whether this particular defendant was predisposed, but whether the government's conduct would have induced a normally law-abiding person to commit the crime. This standard is more protective of defendants because it focuses on police behavior rather than defendant character, but it is the minority approach. Real-world application. Two scenarios. Both involve undercover operations. Only one is entrapment. Scenario 1. An undercover DEA agent poses as a drug buyer and approaches a man known in the community as a dealer. The agent asks to buy cocaine. The man immediately agrees, names a price, and completes the transaction. This is not entrapment. The government provided an opportunity. The defendant was predisposed. He was already in the business of selling drugs. His immediate willingness proves it. Scenario 2. A man with no criminal record and no prior drug involvement loses his job and falls into financial desperation. An informant working for the FBI approaches him repeatedly over 4 months. The informant appeals to their friendship, tells elaborate stories about people who will be hurt if the man does not help, offers increasingly large sums of money, and eventually the financially desperate man agrees to transport a package he is told contains drugs. At the moment of arrest, the package does contain drugs placed there by the FBI. This scenario has the elements of a genuine entrapment defense. No prior criminal record, no predisposition, extended government inducement over months, emotional manipulation, financial exploitation. A good defense attorney takes this to trial with an entrapment defense. Whether it succeeds depends entirely on the jury and the specific evidence of predisposition the prosecutor presents. Common mistakes. The first mistake is assuming entrapment applies any time an undercover officer was involved. The presence of an undercover officer alone does not create an entrapment defense. The officer must have gone beyond providing opportunity into active inducement, and the defendant must have had no predisposition. Most undercover operations do not come close to legal entrapment. The second mistake is raising entrapment without understanding it concedes the act. When a defendant claims entrapment, they are legally admitting they committed the act charged. They are arguing the government made them do it. Raising entrapment and simultaneously arguing you did not commit the act are contradictory positions. Your attorney must make a strategic decision about which defense to pursue. The third mistake is having a prior record and expecting entrapment to succeed. Prior convictions for similar offences are devastating to an entrapment defence because they establish predisposition almost automatically. A defendant with 2 prior drug convictions arguing they were not predisposed to drug offences faces an almost impossible task in front of a jury. The fourth mistake is not documenting all government contact immediately. The timeline of when contact began, how many times requests were made, what emotional pressure was applied, what promises were made. All of this must be reconstructed as evidence for the entrapment defense. Memories fade. Document everything immediately and provide it all to your attorney. The fifth mistake is not exploring derivative entrapment. In some cases, the defendant was not contacted by an officer directly, but by a government informant. Informants working for law enforcement are treated the same as officers for entrapment purposes. If an informant induced you into criminal activity on behalf of the government, entrapment may apply regardless of whether you ever spoke directly to a law enforcement officer. Your action. Steps 1. If you believe you were induced into criminal activity by an undercover officer or government informant, document the entire history of your relationship with that person immediately. Every contact, every request they made, every time you refused, every form of pressure applied. This timeline is the foundation of an entrapment defense. 2. Contact a criminal defense attorney immediately and specifically discuss whether entrapment applies to your situation. This is a highly strategic defense that requires careful evaluation of all facts before it is raised. 3. Do not discuss your case with anyone except your attorney. Statements you make about your prior knowledge of or willingness to engage in the criminal activity will be used by prosecutors to establish predisposition and destroy your entrapment defense. 4. Research whether your state uses the subjective predisposition test or the objective reasonable person test for entrapment. The applicable standard fundamentally changes the strategy and the evidence your attorney will present. 5. If a government informant was involved, your attorney must immediately investigate that informant's background, their agreement with the government, their compensation, and their history of prior cooperation. Informant credibility is often highly vulnerable, and attacking it is central to many entrapment defenses. The government has enormous power to investigate and prosecute crime. Undercover operations are a legitimate and necessary tool. But that power ends where manufactured crime begins. When the government creates criminals instead of catching them, the law provides a defense. Know where that line is. Share this with someone who needs to understand how undercover law enforcement actually operates. And for any real legal situation, always speak with a licensed criminal defense attorney in your state immediately.